Welcome to the midweek edition of LegalAF with your hosts. I'm Michael Popok.
I'm Karen Friedman Agnifilo.
Hi, Karen. How are you?
I'm good. How are you?
I'm doing great. I'm in New York. You look like you're in Blurry Town. Where are you?
I'm in New York also, but I'm in a different part of New York, all the way in upstate New York near the Canadian border. There's a lot of poutine and French words everywhere. So it's very, very high up north.
Cool. And thank you for making time for me and our audience to continue what we're doing midweek with LegalAF. And on this 30-minute episode, we'll focus on Justice Breyer, the confirmation process, and the shortlist to replace him when he finishes this term, and the affirmative action myth, unfortunately, Karen, that the Republicans have now latched onto to cloud and defame this pick even before it's actually made. Our president, President Biden, has decided, rightly so, that he's going to use this opportunity. It's a once or twice in a lifetime opportunity to pick the first Black woman in 230 years on the court, and bravo to that. And of course, the Republicans hate that and have attacked the pick even before it's been made as being a product of affirmative action. So let's get down to the things we're going to talk about. Let's start with, I'll kick it off with the legacy of Stephen Breyer, because Karen, I found it interesting in all of the tumult about his stepping down and all the hand-wringing about will he or won't he, is it going to be like, unfortunately, like Ruth Bader Ginsburg, and it's going to happen so late that the Democrat doesn't get to make the pick, or is he going to step off? What's been lost in that shuffle is the legacy of Stephen Breyer and what he accomplished since being on the court appointed by Clinton in 1994. People just think, well, he's that old guy on the Supreme Court, but frankly, without Stephen Breyer, many of the majority decisions that we hold dear in the last 25 or 30 years would not have been accomplished. At one point, when Kennedy stepped down, there was even talk that it had become, for a moment, the Breyer court, because he ruled in the majority decision on most of the term for about 3 terms running after Kennedy stepped down. And so the question that progressives have, like me, I think like you, is, do we just want a liberal to be selected to sit in that chair and we're content with losing 6-3 on every major decision? Or do we want somebody to fill the shoes of Justice Breyer and build consensus and do it? And he was a technical writer. He was not an eloquent writer. He's not Kagan's equal, for instance, but he was able to find consensus across the aisle and to turn what could have been 6-3 and 7-2 decisions against him into 5-4 or 7-2 decisions in favor of his position. And so it's not just about picking somebody. It's picking someone to replace him that can hold the intellectual heft, that has the intellectual heft to help forge consensus. And so we're going to talk about each of the major top 5 short picks, and we'll get your opinion, and I'll weigh in as to, is this the person to follow in the big shoes of Stephen Breyer or not? But let's talk about his legacy for a moment before we turn the page on his career. He is going to be staying for the entire term, which is a good thing. I'm here to tell people that's a good thing, not a bad thing. When the abortion decision in Dobbs versus Mississippi is yet to be decided and the opinion yet to be written, when affirmative action has now been taken up by this Supreme Court. That's a good thing that Stephen Breyer, with his heft, with his 30 years of experience, with his gravitas, is sitting in the chair. Their Second Amendment issues have not yet been resolved. The New York case about concealed weapons. So I'm glad that Stephen Breyer is in the chair. And as you'll discuss in the confirmation section or segment of today's 30 minutes, the fact that he's going to stay till the end of the term does not mean that there's going to be a delay in the confirmation process at all. So nobody has to worry about the hand-wringing. He's got to go and, hurry up. No, let him finish out the term, do the right thing, and we will get an appointment right behind it that will take his place when this term ends. The legacy of Stephen Breyer, because people forget this, every major abortion decision affirming the constitutional right to an abortion in the last 30 years was authored by Stephen Breyer. We forget that in all of the run-up and all of the Texas SB 8 issues, that if you look at his legacy, one of compromise, one of an alchemist converting opposition into consensus, which is what we need. A person in his 2 memoirs that he wrote believes in participatory self-government, that the
he called it what? Active liberty, right? Is that what he called it?
Active liberty. That's right. Not activist judges. Active liberty. That the Constitution is a democratic document, and that the role of the judges is to preserve that. And the battle, you know who his battle mate was for 25 years on that court was who, Karen?
Scalia.
1000%. So the battle, the existential fight for the soul of the Supreme Court was really a battle between, a friendly battle, because they were friends and colleagues, between Antonin Scalia, who was a textualist, who was an originalist, who believed you just looked into the minds of the founding fathers and what would they do is the answer to every interpretation or construction of the Supreme Court. And on the other side of the continuum, you have Stephen Breyer, who said, we have a modern role, the judiciary. We understand that the country is split almost 50-50 on most social, religious issues, but the role of the Supreme Court is to use judicial authority to bridge those gaps and make proper law under the interpretation of the Constitution. So that was a battle that went on forever. Karen, I'm sorry, go ahead.
No, I think you're 100% right. I think Breyer acknowledged, however, that way of being a judge also has flaws, because he encouraged the active participation of the people in the court, in addition to interpreting what the law is and interpreting precedent. But we've seen throughout history that can also be fraught with peril, right? Like the Dred Scott decision was one. I think that he acknowledged that his active participation or active liberty by letting people participate in sort of what should happen, what the courts should do, that can also lead to tricky and negative consequences. What I found really interesting, what I have always found very interesting, is you think of a judge as not being political. You think of it as a lawyer coming up. You want a judge to call it like they see it, call balls and strikes, as they say. You don't want them to have an agenda. You don't want them to have some kind of legislating from the bench. You want them to be the grown-up in the room, to be able to look at the advocates, if you will, who are advocating for one position or another, and interpret the law in a fair way. And so I've always found it surprising that you have the smartest people in the land, you would argue, are the people in the Supreme Court. These are the smartest of the smart, the really, really most went to Harvard or Yale or Stanford, and they're brainiacs. They're the really smart ones in the room. And you would think, though, that they would all land in the same place if you're just interpreting the law. But people that you could end up on such wildly different sides of an argument. I've always found that really interesting and fascinating, because they shouldn't be partisan, and they shouldn't be legislating from the bench. And one of the things that, to get back to your point about what's going to go into this decision, if you pick, let's say Biden said, you know what, this is the moment I'm going to pick the most progressive, the most liberal, and the youngest, because I want that person to be on the court for the next 60 years. Because, as we all know, they serve until they retire.
Right. So that would be Kruger.
So exactly. So,
right.
so you let's say that's what Biden did. I would argue that that's not the smart move, because then all you're doing is it could be the smartest, most qualified person. However, they're just going to be writing dissents for the entire time that they're a judge, or at least until hopefully one day the balance goes back to be more balanced. But I think the most important thing is somebody who is a consensus, who can bring both intellect and consensus to the court and reason to the court. I mean, there are some cases that are just bringing some very unreasonable positions, and I think bringing some level reasoning to the court, I think, is important. And I think many of the judges, surprisingly, even if they are quote unquote conservative or quote unquote liberal, at the end of the day, they are very reasonable and can often come to consensus in certain matters and in certain cases. So I think it's very important here that a lot of people are saying he's got to pick the most qualified. And, when you use the term affirmative action as if that's a dirty word, as if that's a negative, it's you're not using it as a positive, right? So whatever it is, in addition to being the most qualified, the best, there are other factors that go into picking a judge. And I think one of them is what you alluded to, is this ability to continue the Breyer legacy and to bring people together, to bring the judges together, and really think about both what the real life consequences will be to their actions and try and build a consensus, because the rest of us are the ones who live with the consequences of what their decisions are.
I think Breyer was on the court long enough where he was able to experience conservative, and I'm going to use that term accurately, conservative restraint, which was exhibited by Chief Justice Rehnquist, joined by Sandra Day O'Connor, all the way to what we have now, which is conservative activism. There's no other word for it. The very thing that the conservatives had attacked the Democrats, the progressives for years, which was judicial activism, is exactly what they're doing. There's no other explanation for why the court is calling up precedent, some of which is only 5 and 10 years old, and reevaluating it now that they have the numbers. That is not the way the Supreme Court that I studied in law school, you studied in law school, is supposed to work. And if they want to be out of the political fray and they act and they fake clutch their pearls every time somebody attacks them for being political. They spent the whole summer, most of them, on the lecture circuit saying, we're not political, we're above politics. Well, then don't call up precedent like abortion that's been on the books for 50 years, like Second Amendment, like affirmative action that's already been decided. You're not supposed to reevaluate every 5 and 10 years Supreme Court precedent. The mores of the country haven't moved that far. So nothing has happened other than you got the numbers, and that's not supposed to happen. So look, from Breyer, just to remind people, and then we're going to move on to and let you lead on confirmation process. He authored Steinberg versus Carhart, 2000 case involving Nebraska, which upheld the fundamental right to an abortion. June versus Russo, which also was struck down a Louisiana law in 2010 that required abortion doctors to have hospital admission rights. He was on the leading edge of religious freedom in a 2005 case called Van Orden versus Perry, which allowed a actual physical embodiment of the 10 Commandments to sit in Texas. He wrote dissents that were powerful in death penalty. He basically was one of the justices, most of them are, who believes that at least lethal injection is cruel and unusual punishment under the Eighth Amendment. And, there was no, because he's leaving, he's got one last shot with Mississippi versus Dobbs. There is no greater vanguard to the fundamental right to abortion than Breyer. And he's got big shoes to fill, which we will cover in the last segment on the short list. But let's talk about the confirmation process, Karen, and because there's been a lot of hand wringing among our followers and listeners about how does this work and what happens and what does the Senate Judiciary Committee do? All right. And what's the timeline for it? Let's walk them through it.
So as everybody knows, the Constitution of the United States sets out 3 separate but equal branches of government in Articles 1, 2, and 3. And in Article 3 is where they talk about the judicial branch. And that's where the Supreme Court of the United States, the process or the procedure occurs. And it really involves all 3 branches. They really seek to involve the executive branch and the legislative branch in order to confirm and pick the judicial branch nominee. And so the way it works is the president usually meets with the various candidates and shortlist, and then they pick somebody for the position. They then present that position to the Senate. Usually they consult with the Senate before announcing the person, because really they want their individual to be selected, right? They don't want to put someone on that's not going to be selected. So they try to do a little bit of a vetting ahead of time with the Senate. And then they send it to the Senate Judiciary Committee. Now, the Senate and the House have committees, many committees, and committees have certain members that sit on them, and certain committees are more prestigious than others, and you get selected to be on the committee, and people want to be on certain committees and not others. And whoever's in charge of the ruling party is who chairs the committee and has the majority of members. So the Senate Judiciary Committee is the one that vets the candidate and sort of does the kick the tires, and they read all the opinions, and they have an FBI background check and all of that. And
who's the chair of the committee?
It's I'm going to go out and say that we need to retire the name Dick. His name is Dick Durbin. I think it's time to retire that name. And I'm happy to retire the name Karen too, by the way. So let's go by Richard or something else. But his name is Dick Durbin. He's a Democrat from Illinois. And he's the chair of the Judiciary Committee. And I think there's 20 or 22 people members.
There's 22 split equally, 11-11. Republican and Democrat.
I actually read that somewhere, but then when I looked at the members, you count them, it turns out to be 20. But so there's I think 22. I agree with you, and basically they hold a hearing, and at the hearing, it usually takes on average 3 days for the hearing. Usually this takes place approximately 1 month after the president gives the name, because they spend a month sort of again preparing and doing their homework on the candidate, and the candidate themselves prepares. There's a lot of preparation that goes in. I have several friends who have gone before the Senate for confirmation to be a judge, and there's a lot of preparation that goes into it, and so there will be preparation on both sides. And also, one thing I didn't know until recently, that witnesses can also present evidence on behalf of this nomination. And the candidates.
Anita Hill was a witness.
Yeah, exactly. There you go. That's true. I guess I just never thought of it like that. I never until I was very young during the Anita Hill process. So it's only thinking about it now that I've been a lawyer for so long that it's just interesting to think about that you can have witnesses. And I guess you're right. Same thing with one of our recent confirmations as well. Anyhow, so the candidates questioned, and then they vote. And there's either a yes, a no, or I take no position that happens. And that's a recommendation to the full Senate. And then it goes to the full Senate, and the full Senate debates the nomination, and then they vote. Now, it used to be that the Senate was allowed unlimited debate, which is also known as the filibuster, when it came to judicial appointments. And so what would happen is, if somebody was being pushed through that people didn't like, you would be able to filibuster, and in order to get past a filibuster, you need a 3/5 majority, or 60 senators, which is also known as a cloture vote. But in April 2017, the Senate, by Mitch McConnell, changed the rule in order to get Neil Gorsuch, pushed through and nominated, and lowered the requirement to a simple majority, which would just be 51 for Supreme Court nominations. And look, at the time, I'm sure, at the time, many people were unhappy with the fact that the rules changed, but you got to be careful what you wish for, because now it benefits us, right?
You live by the sword, you die by the sword.
Exactly. Yeah. And so they have a debate, then the Senate votes, and a simple majority here would win. And if there's a tie,
who breaks the tie, right? Mm-hmm.
So, right, the Vice President, Kamala Harris. she would be the one to break the tie, which is why, because the Senate is 50-50, there's 100 senators and there's 50 Democrats and 50 Republicans. The reason the Democrats hold all the majority positions on the committees is because of the vice presidential tiebreaker. They are considered having a majority. But that's why it's so important that you can't take a single vote for granted. And I know that they're trying to rush through this process, which normally historically takes about 3 months. Although Amy Coney Barrett only took 1 month recently, they're trying to get the Barrett treatment here for Biden's candidate, because first of all, the midterm elections are coming up in November, and there's no guarantee that the Democrats will hold on to the number of Senate seats that they have. They could lose some, but even more importantly than that, anything could happen. Somebody could be hit by a bus, God forbid, or somebody could be sick.
Let's get to more specifics. So let me give our followers and listeners who's on this panel and some of their ages and some of their past personal health issues, which are problematic. So on the Democratic side, besides Durbin, you have Leahy, who's pushing 90 and is from Vermont and is the majority ranking member. And although he's very good for progressive Democrats, he had a period recently where he took ill. And if you take ill and you're unable to vote, there's one less vote. The other person who's on the panel on the Democratic side is Dianne Feinstein, who's 90. So we have two people on there, and I'll just run down the list so people in the various states that our LegalAFers reside will know how important their senators are. Leahy, Feinstein, Whitehouse, Klobuchar from Minnesota, and we'll talk about her in the shortlist issues. Coons, Delaware, Blumenthal, Connecticut, Hirono, Hawaii, Cory Booker from New Jersey, Padilla from California, and Ossoff, Ossoff, who had the runoff election in Georgia. On the other side of the aisle, I won't name everybody, but Cruz is on there. Hawley is on there, he of the Jan 6 fame or infamy. Kennedy, the wrong Kennedy, and Lindsey Graham, which we'll also talk about in the short list because he's got a pivotal role here. If this panel is going to vote to recommend, it's going to go through, I think, Graham, and then we'll talk about the short list related to that. So I thought one interesting little bit of factoid that I picked up in our research for today is that 20% of Supreme Court nominees have been rejected by the Senate historically. And the very first nominee made by George Washington in 1789 was rejected by the Senate. So it happens. It's not going to happen here. I want to blow a little sunshine on this podcast because we've got a lot of people that are worried and stressing out about whether we're going to get this pick through in 37 or 40 days. And I'm here to tell everybody we are. We have the votes. They're going to do a process. It's going to be properly vetted. The Biden staffers are going to work closely with the Durbin and the Judiciary Committee staffers. They're going to vet the 5 or 6 candidates. They're going to focus on the one that Biden wants. And if a couple drop off because of the vetting, somebody wrote an opinion that doesn't look so great, we're going to lose some votes on this one. They're going to turn to the easier candidate. And that person in the next 40 days or so is going to be confirmed with Kamala Harris voting in favor of it by this Senate. And then they will be just awaiting their actual swearing in. Once Breyer steps down at the end of this term, that person will slide right in. And slide right in probably to the clerks, because that person will not have had time to vet fully their own clerks to bring with them, those all-important Supreme Court clerks. They'll probably bring 1 or 2 with them from their current, most of them are judges that are being focused on. They'll bring some of their clerks with them, but I assume they'll pick up Breyer clerks who had a 2-year commitment, and they'll use the Breyer clerks until the following term when they can pick their own. This is a very exciting time. Anything else on confirmation we need to cover, or should we move on to shortlist?
I think we can move on to shortlist, but really quick, I also learned through this process, frankly, you don't have to be a judge to be a Supreme Court justice. You don't even have to be a lawyer. You don't have to be a natural born citizen. So unlike presidential requirements, that you have a lot more ability to pick people. I just found some of those things interesting. I also found it interesting that the Supreme Court originally sat in New York when it was first created, and then it moved to Philadelphia, and then then after a while to where it is now in Washington, D.C. But so getting to the picks.
Well, before you leave though, to your point, Kagan was not a judge. She was She was an acting Solicitor General for a period, but Kagan was not a judge before she was put on to the. She had her judicial position blocked for a while and never made it to a bench. Her first time being a judge. Talk about great results. Her first time as a judge as a U.S. Supreme Court justice.
You hear a lot of people who talk about this promise that Joe Biden made to pick a Black woman as an affirmative action pick, but I'd flip that. What is the qualifications to be a Supreme Court judge, and what are people looking for? They say the best person, the most qualified. Okay, but what makes somebody qualified? What makes someone the best person? Some people would say judicial experience. Some people would say, I think it just depends on kind of where you're coming from. And I just want to say that, and I can't believe I'm about to say this, but I think the person who I would like to quote here is Lindsey Graham, who was talking about Michelle Childs, who is one of the shortlisted people, and the person that I am going to say is probably going to be the nomination. That's the person I'm guessing. And Lindsey Graham says that Michelle Childs, who we'll get to who she is in a minute and what her qualifications are, but I just want to set the table. This is a Republican saying Michelle Childs is qualified by every measure, one of the most decent people I've ever met. I can't think of a better person. Okay, fair-minded, highly gifted, highly qualified, put me in the camp of making sure the court and other institutions look like America. She is not an affirmative action pick if you pick her. So I think, first of all, coming from Lindsey Graham, that should show a couple of things. Number one, here we've got a consensus person. You've got a consensus candidate. You've got someone who's willing to cross the aisle and reach across the aisle and say, this is a great candidate. But what I also thought was interesting is you've got a lot of people, conservative people out there saying affirmative action candidate. And I think he put it perfectly, that we should make sure that the court and other institutions look more like America. And I think that that is a qualification. I think there's so many brilliant lawyers out there and brilliant judges. And I mean, just with an encyclopedic knowledge of the history of the law and the ability to analyze and interpret the law, but might not have a lot of life experience or might not have great judgment. I mean, there are other things that go into what would make you a great judge. And you can't possibly say that you, as a white man, Michael Popok, who walk around the streets every single day and you interact with people, that your life experiences are identical to someone who walks around every day who's a person of color or a woman. I mean, just people will react to you differently. That just the mere fact that Biden saying, I'm going to pick a Black woman, people say affirmative action. I mean, if he were to say, when Ronald Reagan said, I'm going to pick a woman, were people saying anything about that? No.
Oh, because we lived in a different political time where nominees, even like Scalia, got confirmed 98-0. And we don't live in those times anymore.
But I also think it's an acknowledgement that the minute you say that you talk about a person of color, that automatically people don't say, wow, okay, for sure, that's going to be the most qualified. Automatically people say somehow they are less than. Somehow this is affirmative action. Somehow you're not going to find the most qualified person and a person of color. And I just find that kind of...
it's a racist dog whistle that they've been blowing for a long, long time. It is, I'll use a Yiddish phrase, it is a shonder, it is a shame, it is a black mark that this is in 2022, that we're even talking about the need to appoint the first Black woman in 230 years. We should be talking at this point about the fifth or sixth, or not even be talking about the fact that a person of color is being appointed or not appointed. I mean, back in the old days, they would talk about, well, Thurgood Marshall was black. We better put another black person in there. It's the black seat. So that's how we got Clarence Thomas. Or when Sandra Day O'Connor left and they were replaced. When Ruth Bader Ginsburg left, the woman's seat. I'm so tired of the seats, but if we're going to elevate somebody, and there's so many qualified people, and so many people to say that we should always pick the best and the brightest. And therefore, the best and the brightest was Brett Kavanaugh. The best and the brightest was Clarence Thomas. The best and the brightest was, Amy Coney Barrett. Amy Coney Barrett was one of probably 50 people that were qualified for that job, including many, many people of color and different sexual orientation. So for the Republicans to say, oh, we only stand for judicial competence, and it must be an affirmative action pick that he's picking a woman of color is just a dog whistle to their base, which is disgusting, which, you and I and others that follow us should be against.
Of course. And of course, the person should be the best and the brightest and the most qualified. That goes without saying. But there, as you just said, are so many people that are the best and the brightest. There's no one best. There's no sort of Albert Einstein of judges, to my knowledge, right? It's a lot of different things, and you want different perspectives and different life experiences, because so much of what they do is not just legal interpretation, but it's also judgment. And so I think people should consider in the future having an Asian individual perhaps also be on the court, or an LGBTQ person on the court. I think those are factors that should go into consideration when thinking about maybe someone who's not either Jewish or Christian/Catholic on the court, right? I mean, I do think it's important that the court be more diverse. And I think, as you pointed out, and as lots of people are saying, and as Lindsey Graham is saying, my new favorite person, at least for right now, for this one moment in time, it should look more like America. And I think Biden, it's not about being a campaign promise. It's about recognizing the obvious. And the obvious is that it's absolutely time for a woman of color. And go ahead.
The balance to Lindsey Graham is because he is Machiavellian in his decision making. It's not because he just really likes Michelle Childs. He knows, and this is credit to the fact that we're in power at the moment, he knows that he's not going to be able to stop the freight train of Biden picking a black woman. Biden has said he's going to do that. But Graham wants to be the kingmaker and decide which black woman, and he knows her. He's met her. They're from South Carolina. He feels comfortable with her. I'm not sure if that's a good or a bad thing. He doesn't know Ketanji Jackson. He doesn't know Leandra Kruger. He doesn't know, the rest of the candidates who we're going to talk about before we're done here. But, and so he's jumping on the train before he gets run over by it. But his vote is really important because he's one of the 22 on the Senate Judiciary Committee. And if he gets on there, and then you have, let's be frank, as we continue to talk about Childs, then I want to move to the other two of the short list. You also have Clyburn, and Biden, it would not be president today. There's no doubt about it if he had not won South Carolina.
And Clyburn was responsible for that. He delivered.
And Clyburn said, "Don't praise me, deliver for me." I'm paraphrasing. Yeah. So, there's a lot of good reasons to pick Michelle Childs, hopefully Justice Childs. But let's turn to Ketanji Jackson and Leandra Kruger, because those two are also very well qualified and on the short list. You want to start with Ketanji Brown Jackson?
Yeah, so Judge Ketanji Brown Jackson, she's I think 50 or 51 years old. Many legal scholars believe she is the front runner just from qualification. She's currently a judge on the U.S. Court of Appeals for the D.C. Circuit, which has long been considered a pipeline for the Supreme Court. And it's the appellate court feed at the appellate court level that feeds the Supreme Court, and it's located in DC, and it's a very important circuit court. So that's one reason I think people believe she's a front runner. She's also double Harvard, unlike Judge Childs, who we just discussed, who went to state schools. She's not Ivy League.
And Duke University for her LLM.
Smart as, so I'm not saying she's not brilliant, but she's more of a public school person, and Judge Jackson comes up sort of more traditional Ivy League, the way the other candidates. She's also sort of unusual, has an unusual background for a Supreme Court justice. She brings professional diversity in addition to diversity by being a Black woman, which she was a former public defender. And I do think that perspective, and not just because I come up in the criminal justice background, but I do think that's a very important perspective to have. And I think that's a good, that'll be really good for the court to have someone with that background. And she's also used to handling big cases. She was the judge that handled some of the Trump January 6th disclosure cases on appeal.
The National Archive, the National Archive case.
Yeah. So I would have said she was my top pick until Michelle Childs, when I saw kind of the consensus building that I think she will bring to the table. And so now I'm going with Michelle Childs as my top pick, but I'd say Judge Ketanji Brown Jackson is my second, or tied for first.
Yeah, before we leave her, so I like her a lot. We on LegalAF with Ben Meiselas, we spent a lot of time talking about her decisions in the National Archive case. She's super bright, as you said. DC Circuit Court of Appeals is often a feeder program directly into the Supreme Court. She's a Florida person. She went to Miami. She graduated from Palmetto High School, where Jeff Bezos went. And she, like you said, she brings other aspects of life experience diversity that's important. And let's talk about age for a minute. She's the right age. Supreme Court justices, they like them to be in their 50s, maybe in their late 40s, because presidents want a legacy and want these people to be on for 20 and 30 years or more. That's why when you get to about 60, and Merrick Garland was sort of on the far end when he was nominated. Of course, he was blocked by Mitch McConnell, but he was on the far end anyway. Ruth Bader Ginsburg was actually on the far end of it as well in that historic pick. But I liked her a lot, and as you said, and I still like her. But I think with Lindsey Graham blowing that dog whistle of to get his people supporting that candidate and giving some cover to some of these nutty Republicans that are claiming it's an affirmative action pick, I agree with you. I think Childs is the way is probably the path of least resistance to get a nomination passed. Now let's talk about Leandra Kruger, who is the youngest of the candidates. She was the youngest California Supreme Court justice at about 37 or 36. And now at 45, she'd be one of the younger of the Supreme Court. You want to talk about Leandra?
Yeah, so she went to Yale Law School. She was the editor-in-chief of the Yale Law Review, which is, for anyone who didn't go to law school, the law review for each law school, you have to either grade on or write on to it, which means you have to be really, really smart and really good to be selected and chosen to be on law review, and it's considered very prestigious. And then to be the editor-in-chief of the prestigious law review is sort of a huge badge of honor. So she's very smart.
And the first Black woman to ever be the editor-in-chief.
Yes, that is true. She's the first Black. So she is really smart. She was a former clerk in the Supreme Court. And I forgot to mention Judge Brown Jackson clerked for Breyer. Yeah, that's right. But Leandra Kruger, she was former clerk for Justice John Paul Stevens. She's considered more moderate. So she would be sort of a middle of the road pick. She's known to be cautious and deliberate. And in general, I think she's be an excellent pick. I don't think we'd go wrong with all three of these picks. I mean, none
Agreed.
of them are lightning rod, super progressive kind of. I think all three of them could be excellent consensus builders who could, I think, make a big difference, and they'd be excellent picks and are eminently qualified and excellent, and certainly the best of the best our country has to offer. And anyone who would say otherwise for these three picks, I think I can't imagine that they would say that, certainly with what we know now. But that's what the confirmation process is for, right? You never know what could come up in the confirmation process. Had it not been for Justice Thomas's confirmation process, we wouldn't have known about Anita Hill, right? Or so I mean, it does come up. It does come up, these dark skeletons in people's past. Hopefully they don't have any, and sort of kick the tires. And I think barring kind of anything crazy that comes up, I think these three are phenomenal picks, and we couldn't do wrong with any of them. But my money, if I was a betting person, goes first to Childs, second to Brown Jackson, and third to Kruger. It's just who's going to be the pick.
I think you have it exactly right. Well, we've reached the end of another thought-provoking and timely midweek edition of Legal AF with Michael Popok and
KFA.
Okay. By the way, on that note, I did not name you KFA. Some people thought it's insulting. You're calling her KFA. That is a nickname you've earned in your life. Close friends call you that.
It actually came up professionally. I think mostly because my last name is such a handful and so hard to pronounce, and no one really knew how to do it. And I didn't ever call myself KFA until the name Karen became kind of a negative, pejorative kind of term. And so now I used to, of course, I mean, it was a term of endearment and something that I appreciated, and I thought it was funny. But now I embrace it because I'm happy to retire the name Karen too. So
you're our favorite, Karen. So join us every Wednesday when we do a deep dive and analytics about a cutting edge legal and political issue. And of course, every weekend, join my co-anchor Ben Meiselas on Saturday night and Sundays for the regular end of the week roundup of the top dozen or so legal and political news stories. We do it on YouTube, and then we launch it on all the pod platforms. So signing off, see everybody this weekend. I'm Michael Popok.